Thank you, Chairman. Welcome, Professor Jacoby. I see that the lawyer witnesses who support the corporate two-step have maneuvered to outnumber you 3-1 on this panel. So stand your ground. It's good to have you here. Ms. Knapp offered a pretty compelling point, which is that by virtue of stalling her dad's recovery until after he had died, the system, the corporate potentially liable party here, was able to extinguish his pain and suffering claims, make them vanish. Whereas if they'd had to address them while he was alive, they would be a part of his recovery. Is that a legitimate use of delay by corporate defendants? And is it a real problem? Is she stating something that is a significant problem we should pay attention to?
Senator Whitehouse, I think your question goes to the very different environment of mass tort cases, especially preceded by divisive mergers where there's not an operating company in bankruptcy. And the great majority of commercial, big corporate Chapter 11s that I believe that Mr. Hessler spends his time on, where it's less likely that one would fall into this circumstance. There should be many tools to keep Chapter 11s moving. If anything, some Chapter 11s may go too quickly, but that is not what's happening here in these divisive merger cases. They are indeed stalled, and there are real consequences.
That's what I was trying to get you to.
I'm sorry, Senator Whitehouse. Life and death. And I think that is very important. It's bankruptcy and the experts in bankruptcy talk a lot about money. And of course they do. And in a lot of situations, that's all that's at stake. These kind of claims involve accountability, making sure something like this doesn't happen again, honoring and acknowledging misconduct and letting people tell their stories. And bankruptcy is not designed for all of those things. Maybe it could be. So I am very worried about the concerns that you raised, Senator Whitehouse.
So let's talk a little bit more about money. Mr. Haas made the point that the Johnson & Johnson bankruptcy fund measured favorably against the assets of the subsidiary JJCI. It strikes me that Johnson & Johnson controls what assets are in JJCI. There are innumerable ways within a corporate structure of moving assets between subsidiaries. Why should the argument that we're doing better than our divided subsidiary would provide be given any credence at all when that measure, when that bar can be driven right to the ground by the very people who are seeking to dodge their responsibilities?
This question again goes to, I think, a division we see between the average commercial case and what's going on, especially in the divisive merger cases designed only for personal injury, wrongful death claims, and other mass tort contexts. Typically, corporate form is honored in bankruptcy, that the entity that has filed, we look to that. There are tools, I think as Senator Graham mentioned, such as fraudulent transfer, to consider various corporate transfers. We also do need to look at non-bankruptcy tort law.
Quick interruption on fraudulent transfers. Are you aware of any fraudulent transfer challenge in a Texas two-step type proceeding that has ever succeeded?
It takes a long time to tee them up. I believe they are underway, but it may be years until they were resolved.
Got it. Okay. And then what is the risk of forum shopping here, where a big corporation that's doing business all over the country can pick the jurisdiction in which they love the bankruptcy judge the most because he's the worst judge for plaintiffs and the best judge for the corporation?
These cases involve two layers of forum shopping. One is opting one's problems into the bankruptcy regime in the first place, rather than state court, rather than the MDL, other federal courts or fora. Then we get to the question that bankruptcy's corporate venue choices are unlike any other civil procedure rules I'm aware of in the federal system. The amount of latitude given to a big enterprise to choose its forum does not match how we typically do personal jurisdiction, how we typically do venue rules, and that does give a lot of latitude. I think there are a lot of reasons that a particular court might be selected, but this is a continuing issue really in the full range of corporate bankruptcy cases, but also we can see in mass tort cases.
Thank you. All right, time's expired, and you're holding up very well outnumbered.